Thank you very much for joining us, and we are going to host a webinar on force majeure in a pandemic, and in particular whether to litigate or whether you're going to need to use project management skills to resolve the issues arising from force majeure. We think there's going to be a topic that is going to be on every business's mind, and I'm absolutely delighted today to say that I'm joined by Sloane Perez, who's Vice President, General Counsel, and Chief Ethics Officer of Force Maritime, which is the largest marine tug operator on the West Coast. And I'm going to give a little bit more detail about her in a while. And I'm also joined by Bree Buchanan, and she is in fact the, I need to make sure I get this right. She is Associate General Counsel and Compliance Officer for Neenan Inc., which is a publicly traded company and has a very strong IP background. And again, I'll give you a little bit of bit more detail shortly. I'm also fortunate to be joined by Joe Murphy, my colleague at Miles Mediation and Arbitration, who is going to keep me on the straight and narrow and make sure that I don't talk too much, I hope. And so if I can just give a little bit more background, and then we will launch straight into it. Sloane Perez is a seasoned corporate executive, a leader in global logistics and retail brands with experience in post-acquisition integration of at least 2 top industry leaders. She has transitioned 2 separately large publicly held companies from family control to investor control. She has also experience in cybersecurity, corporate governance, complex regulatory environments. She's General Counsel and Chief Ethics Officer for Force Maritime, which is a 130-year-old harbour and marine services company. She's formerly the Chief Administrative and Legal Officer for 2 privately held retail brands, which you have certainly heard of. As part of her executive teams, she has regularly reviews the company's enterprise risk strategies, which of course is very relevant for today, financial controls, and stays very familiar with business flows of revenue. She's managed the risk management functions, including insurance, for her company, as well as HR risk mitigation and regulatory compliance. She works very closely with the CEO and C-level and has extensive experience in all aspects involved in the General Counsel's role. We're also very fortunate to be joined by Bree Buchanan, who received her BS in Industrial Engineering from Northwestern University and her law degree from Vanderbilt University. She's worked at very large international law firms for over 10 years as an IP litigator, focusing on patent infringement, and went in-house with Neenan, which is a publicly traded fine paper and filtration manufacturer. And for those that hadn't come across that company before, if you happen to enjoy a glass of wine every now and then, the chances are Neenan have produced the label that goes on the wine. But what they also do, which is maybe less well known, is they design and create specialist filters for specialist companies, typically a one-off ad hoc contract, highly complex, very sophisticated, with a lot of intellectual property involved. She is responsible for intellectual property, litigation, workers' compensation, corporate governance, and regulatory compliance, which is a lot. She and her husband, who is actually the US Attorney, Ryan Buchanan, live in Kirkwood and have 2 daughters, 9 and 6. Joe, again, is my colleague, and I'd be very remiss if I didn't mention that for the past, goodness knows how many years, Joe has been selected as one of Georgia's top lawyers. I think he has mediated, I believe it's over 3,000 mediations. I, of course, don't have the notes right in front of me. Joe is a great He does a lot of work in the community. He writes extensively on dispute resolution. He has a background in insurance and corporate disputes, and really focuses in those areas in his mediation role. Those are
Nigel,
our
before you
panelists.
go any further, I think our audience deserves to know a little bit about our moderator. I'd like to say a word or two about you, if I might. Nigel Wright is not only a colleague of mine at Miles, he is a lawyer licensed in Georgia and New York, as well as an English solicitor. You might have picked up on the accent. It's not from Macon, Georgia. Nigel's resume is extensive, but he's been a 5-year in-house in the U.S. for 2 specialty insurance, specialty international insurers. He's held management positions, including in the GC's office, where he was corporate representative handling extra contractual and bad faith claims. When a lot was hanging in the balance and there was complexity in terms of issues and the numbers of people involved, Nigel's the kind of guy that companies would fly around all around the country to be the person handling resolutions of the disputes. He's got over 30 years of ADR experience on topics like the one we're going to be talking about today. Nigel's someone who's been involved with it extensively for a long time at the highest levels, and it's quite my honor to be his colleague. And I'll yield the floor back to you now, Mr. Wright.
Well, thank you, Joe. Slightly embarrassed by that kind introduction, but let's kind of start by just looking at what force majeure is, because it's a very simple concept. It's an unforeseeable circumstance, and I'm reading straight from Wikipedia, just for those who are interested in my legal research. It's an unforeseeable circumstance that prevents someone from fulfilling a contract. So really, we're not interested today in that much about torts, although they can be impacted by force majeure clauses, as we'll come to. And really, there are 3 main areas that we want to address. The first, which is the main discussion point, is commercial contracts and possibly business torts that are impacted by those commercial contracts. Then we'll take a look at some insurance policies and some issues that will arise. And then we might talk a little bit about consumer claims, which are often backed by insurance, and the impact that a force majeure clause may have in those disputes. So anyway, it's taken me far too long to do the introduction. So what I thought I would start with by asking Sloan, what kind of clauses do you have? What kind of force majeure clauses do you come across in your line of business?
We have a couple of different types. A lot of it is driven by the customer's needs as much as our needs. We typically look for some sort of partial or short-term relief. If we as a vendor, as the maritime company, if we are unable to do our job, our customer will often seek for termination, and we try to protect from that. But termination rights are pretty common in force majeure events, extend out over incomplete or over extended periods. The other thing that we try to do is we try to block any outside common law remedy. Now there are, we were talking about this earlier, and I think Joe shared that there are statutory remedies, but what we want is we want the 4 corners of the contract to control, set out the rights. We want to quantify the risk allocation, including the force majeure language. So the customer can push us, and we do have termination clauses within force majeure clauses, but we try not to agree to that.
So Bree, do you get involved in drafting those force majeure clauses within your company?
Absolutely, and we try to have your typical provisions that we try to put in to all of our contracts so that they're try to keep them the same across contracts so that we always know what we're looking for and what we want to include. There may be some contracts where we don't include it. Those will be more typically where we think the force majeure might be on the other side, and we want to make sure that they can't get out of it for that basis unless it's something very, very serious. But most of ours are going to be all very similar.
Joe, I'm sure you've seen lots of different types of clauses come across your desk in your role as mediator. Can you maybe raise and discuss some of the issues that might arise in terms of whether it's a narrow or a broad clause?
Absolutely. Well, one question is going to be, assuming that it's a force majeure situation and it's passed that test. And again, the courts are going to apply a test. First of all, is it a qualifying event? Is this something that would trigger any type of force majeure provision? If it's something that was otherwise perhaps within the four corners of force majeure, but otherwise foreseeable or preventable or subject to being alleviated with mitigation, then there's going to be tons of applicability questions. But again, you're going to look at the provisions in the contract. I think what Bree says is very significant, because what I hear her saying is they like some uniformity across their contract, so that when something hits the fan, all of a sudden, when they turn to their contracts, they know what they're looking for. It's not piecemeal. This one doesn't have it. That one has it. This one's got an act of God provision over here. Is that the same thing? Is it different? There's so many ways that this could scatter if you didn't have a uniformity of execution that would lead to a uniformity of enforcement. One of the questions I have, and that I'm hearing a lot about right now, we're in the period of acute action on contracts that are already in force, but I know with folks like Sloan and Bree, you're constantly executing contracts, everything from short-term deals to 10-year deals. Do you have things on your desk right now that you're maybe looking at differently than you were a month ago?
Bree, do you want to go first?
I'm sure. I mean, we definitely have new ones that have come in, and where that might not have been in there has now been slipped in there with the future seeing of, well, just in case COVID-19 starts affecting us, we want to have this ability to fall back on it. And so now they're more of red flag provisions when we see them, and while we're in this state right now, because we don't want to agree to get into something, and then that would trigger maybe our other force majeure provisions if we have suppliers that aren't able to service us right now, because we are an essential business and we do need to keep running. So we have to be very careful of those provisions as they come in right now.
I'm having similar experiences, except I'm the one trying to slip it in, and not slip it in. The 10-year deal you mentioned is mine. We submitted our red line in the end of December, and of course the customer came back at the end of March. And over that 3-month period, there's been some really significant changes. So we had to announce on our negotiation team call yesterday that we had additional force majeure language, and we've sent it to them. We are also seeing force majeure language come in, and we are having customers request us to go out and get insurance for force majeure directly related to COVID, which, by the way, in a lot of cases is no longer available. And so we have customers who know that we're going to have delays in providing our operations and want to see if we can get insurance that we would then pass over to them, of course, or whether they can obtain insurance even if through us. So we're seeing it in a lot of different ways right now.
Sloan, can I ask you, to what extent do you think the jurisdiction clause within the contract is an important factor when looking at these force majeure clauses?
I think they are important because jurisdictions treat force majeure differently, and in some jurisdictions you must name pandemic versus epidemic as an example, and some jurisdictions are going to say, well, epidemic's close enough. The unfortunate part is there are so many reasons why Bree or I or other companies are selecting choice of law provisions. Force majeure is rarely one of our top reasons. If you're a software company like California and Texas, because they're very protective. If you're on the other end of negotiating a software contract, which we often are as a user, we want to get the heck out of there. And so it's hard to make force majeure one of those important deciding factors. And a lot of companies just default to New York and Delaware, and I don't think they know what the force majeure provisions are at all in either jurisdiction. I know New York, but that is in part from the preparation for this call that I know more about New York than I would have. And I don't think I could even, admittedly tell you how Delaware treats force majeure, but there are a multitude of other reasons why I needed it for a particular contract. So I think that they're going to be, in some cases, determinative of the outcome or determinative of your posture or your strategy. But I'm afraid that most of us aren't looking at choice of law provisions with an eye towards force majeure, or at least we haven't been.
Bree, I think that raises a good point in terms of what you're trying to achieve in your contract. Typically, in my experience, is that companies don't enter a contract in anticipation of litigation. But given the world we live in today and the exposures that companies are facing that they weren't anticipating, to what extent do you think there's greater pressure now in the GC's office to pay attention to each and every clause within a contract, whereas before maybe there was more emphasis on the business generating clauses rather than the remedy clauses?
Well, I think that's the job of the legal department as well, to make sure that they're all worried about all provisions of every contract, really. I think force majeure is going to be a big issue now while this is happening, because it's an actual real issue. I mean, usually force majeure comes up in a one-off situation where one entity, one party to an agreement has had something really serious happen. Now we're in an instance where serious things are happening to multiple people, right? And so we're going to get in this area where everyone's going to have to kind of do some give and take here, and realize that this is a serious issue that will probably delay people and cause these provisions to come up and to actually be applicable for once. But for remedies, I think the way that we do our contracts at NINA, that is one of the numbers that we try to present to the business unit, right? Here are your risks with this contract. Here's what amounts this contract may be worth, the value of the contract versus if there are damages, here are the damages you could kind of look at. We do try to present that stuff to our business units when we are going through a contract.
So Joe, I'm going to turn to you now. So if we have a contract that has a force majeure clause, one of the parties is looking to rely upon that force majeure. What kind of skills do you think are needed to try to resolve that dispute, given that the courts are unlikely to see a jury trial possibly for as much as 18 months?
Good question. And I'm a strong believer of what you just said. The point in time when we will be permitted as a society to voluntarily congregate in groups of 10 or more will come a lot sooner before the government will be able to compel me or any of you to go into a room with 11 other strangers to form a jury and stay confined in that room for some period of time. So we're in a world where alternative dispute resolution is now the pathway that's still open and in a period of time when other pathways are closed. So the first thing I think any mediator or neutral needs to ask when confronting a situation is, what do people want out of it? What are the overarching concerns? And I know I've been in the situation. I've not been a general counsel like Bree or Sloan, but I have been counsel for corporations involved in litigation. And very often the first question is not just what is the acute problem and what are our rights and what are our defenses. It's what is this ongoing business relationship that we've got with these folks? Unlike with a tort where two people might meet for the first and only time in an intersection, there's a T-bone accident, somebody shattered somebody's femur. There's no ongoing relationship that preceded or will succeed this one interaction. I think when you're looking at these types of clauses, one of the questions I would want to know is this a one-off contract? Is this some contract that's a non-essential part of the business, that's a contractor that's coming in and providing some service that's readily available through others? It's not a long-term or a significantly integral part of what this company's doing. I might deal differently. I might lean more on my rights and justice than on broader issues like if I've got a long-term 10-year deal with someone that's providing a really essential service to my business, perhaps a unique service to my business, I might look at that differently. And as an arbitrator or particularly as a mediator, as a neutral, I know I'm approaching a situation where there's a desire for an ongoing relationship. There's a desire more to help this person find ways to perform or to get through the period of non-performance. So there's different objectives. I think the first thing I'd want to know is, what am I dealing with? There's situations that are going to be kid glovier than others. And once you've sort of analyzed that, I think I start there, and then I move to the four corners of what are my rights and how can I lean on those rights to either force compliance or to enforce my desire of not for non-compliance under either force majeure. And at some point, I would like for us to chat about other areas like the act of God provisions that might be in contracts, or in Georgia, we've got a good statute on that. If there's no force majeure in my contract, maybe I'm looking to other sources. But bit of a rambling answer, but I think it starts, as with all problems that you deal with as a neutral, what are the objectives and how do you get the people from point A to point B?
Nigel, can I weigh in on a piece of what Joe's talking about, or maybe a foundation piece? So similar to choice of law provisions, putting arbitration clauses to the side, almost all contracts have some sort of dispute resolution where you have a meet and confer by the parties, and then there's often non-binding mediation, and then either they pivot to arbitration or they pivot to their litigation. And I think the meet and confer between the parties on force majeure is going to be highly charged and emotional right now. And I think that mediators who have a reputation for neutrality and who have the ability to bring parties together to a resolution without litigation are going to become in really high demand. Almost all of my contracts require some sort of meet and confer process. Maybe 70% also have mandatory mediation before you could file litigation or go to arbitration. But even without the mandatory obligation to mediate, in this time where people are so pressured, I think that having that third party to come in more formalized dispute is getting to be more important. I know that I have situations in the past where I've done pre-suit mediations, and I know I have situations now related to force majeure where pre-suit mediation or just bringing a mediator in to help reach a resolution is something that we're exploring in several areas on both sides, customers and vendors.
Thank you, Sloan. I think you raised a really important point, which is that sometimes a third party, whether it's a mediator or whether it's some other third party, can help bridge the gap when there is a significant dispute. And something like force majeure, as you say, is going to be very emotional because one of the parties is claiming, whether rightly or wrongly, that they are unable to perform their contractual obligations. And so understanding whether that's correct, whether there are other motives, what the financial strength, what the importance of that party is or is not to your ongoing business is something that is hard to do on a bilateral basis. But having a third party involved, whoever that happens to be, can help that. And if you think about it, it's really not dissimilar from the good old, collective bargaining disputes that you see, where both parties know what they want to achieve, but they still need somebody else to try and bridge that gap. So I do obviously agree that that's something that I think we might see quite a bit of. And it may not be a traditional mediation. It may simply be we need to talk to you for an hour or two, and it may span a number of days. And it may not be a formal, we start at 9:30 or 10 o'clock and finish at 7. It probably wouldn't be. You may get called in every now and then. So I think that there's going to need to be some flexibility in terms of how those services are used. Bree, I understand, very fortunate in that your business have taken a lot of steps to to look after your employees and to make sure that everybody is safe. And I'm sure you're continuing to manufacture product which is required and necessary at this time. Do you foresee problems that in your supply chain, and how do you think you're going to address them if and when they arise?
So we do try to keep alternative suppliers for a lot of our aspects. So we are not seeing that as of yet, that we are having these delays in our own supply chain. Our numbers have gone down obviously for production as well. So we are looking at our own ability to supply our distributors as well as our suppliers that are coming in. What's more happening for us is that we're not getting our service from our entities that, for instance, maybe provide samples to distributors, right? The businesses that are essential to us, but that are not essential to everyday people. So those businesses have been shut down, and maybe we pay them an ongoing amount per month. So now that question is, while they're not actually performing for the contract, do we really continue to pay that monthly amount, right? And so then it's the question of, will they have the ability to use their force majeure provision as both a shield and a sword, right? Can they say, oh, well, we're not liable for non-performance of our contract and what we were promised there, but maybe we're going to continue to pressure you to continue your monthly payment because you're able to, even though we're not performing you, right? So I think that could be a question that arises later on. But to Joe's point, right, and needing a mediator, and what our company is really thinking of and what we want is, we don't want to get into a litigation, right? We want to be able to resolve these disputes before spending money, right? We are a cost center as the legal department. We are trying to keep costs down. We are going to try to find a way to work with these companies who obviously need something like a monthly payment to keep their businesses running once these orders lift. And we have great relationships with our vendors. So again, like Joe said, we don't necessarily want to destroy those relationships, but we are going to have to find a way to figure out what we do with non-performance, and the fact that, you know, our budget is now changing due to COVID-19 as well.
So Nigel, one of the types of mediation that's really new that we've done recently is we went into an evaluative mediation, which I think you and Joe are probably familiar with, but it wasn't something that I had come across. We actually did many presentations to the mediator, and the mediator's issuing a written opinion. Really interesting concept because, you know, you present witnesses, they're not cross-examined, and the written opinion, of course, is geared towards moving the parties towards a resolution without further litigation. I'm not sure how popular it is outside of construction. We're using it outside of construction, but in unusual circumstances. Is that something that y'all see that might pick up now in that trying to work out without the cost of litigation?
I think so. You could call it arbitration light, if you like, but people need rapid decisions, and mediation may work where you have two parties that just need to negotiate through something. But when you have an actual hard dispute and you need a decision and both parties are happy to go into a semi-binding or a strong recommendation or whatever it happens to be, then I think mediation, an evaluative, which basically means the mediator is given his or her opinion as to what the likely outcome is going to be. That is different to the way that many mediators work historically, which is more, where they try to ask questions and allow the parties to work it out themselves. And even in an evaluative approach, where the mediator is given a written opinion, as with your case, it still has to be agreed upon by the parties. Otherwise, it is an arbitration. I think you might see a lot of one-day arbitrations. Very short, quick. Let's get everything to the arbitrator. Let's have it binding. We'll have a witness each or two witnesses each. I think that may well also arise. Joe, do you have any thoughts on that?
I would agree with what you're saying, Nigel. I mean, my style tends to be more evaluative anyway, and I think that people that pick me as a mediator, I always tell them, look, you're paying for my opinion. You're welcome to it. You can do with it what you will. I can sit around my house all weekend and my family and my wife won't ask my opinion, but I go to work and sometimes people are interested in what I think. So that's a nice thing. But that aside, I think it helps sometimes just to have a perspective of someone who's not so close to something, someone who maybe has general knowledge in the area, but not tied to the interests of the case and looking at it so closely. So I'm always happy to offer an opinion, understanding it's the least important one involved in the mix. And I know my place as far as that's concerned. I do agree with you, Nigel. There's going to be a lot of arbitration light type things, or I call them, one issue arbitrations. I always encourage people to use good old fashioned baseball arbitration. It's a seldom used format, but it might suit well for things like these force majeure issues. Both sides present what they think the resolution should be, and the arbitrator just picks one of them. It doesn't split the baby, but just picks one over the other one. And it forces both sides to create the more reasonable approach, because you're trying to prepare the solution that will be picked. And I think creativity in approaching quick, in and out, easy, neutral involved, or just getting involved and talking to each other solutions. The people that are outside of the box and thinking in that way are going to be the ones who not only survive but thrive in this new environment.
Yeah, I think I'd like to turn at this stage to the fun topic of insurance, because everybody has an opinion, and in fact, I think as recently as today, California gave an opinion what insurers should do with regard to return of premium. But I don't want to address that. What I want to talk about is force majeure in your insurance contract, because at a time of great upheaval and financial distress, people very often turn to their insurers as a mechanism to make good the loss. I mean, they've bought an insurance policy, and the rationale is that if the loss is covered, then they should be paid for it. So I just thought I would, and I'm not sure I'm going to get an answer, but I'm going to ask Sloan and Bree whether they believe that they have an insurance claim, perhaps under their commercial general liability or CGL policy, arising out of losses that their company may have suffered. And so that would be a loss of income, added expense arising out of the events.
So the first place that we looked, and the most often place that we have kind of business interruption, is under our property policies. And so our position is, if one of our vessels is contaminated, that's damage to the vessel has to go out of service potentially up to 14 days. Our crew goes out of service for potentially up to 14 days, if not longer. And that to us is sufficient to hurdle you must have some sort of damage to trigger the policy. And it's similar under our GL policy as well. Those are novel arguments, because the last real pandemic like this in the US was the Spanish flu, which was over 100 years ago. So nobody's sure how it's going to come out, but we are certainly positioning, we're tracking our costs, we're tracking the lost business when vessels go down. We're separately tracking just lost business in general related to the government shutdowns, and then lost business related to the pandemic. And so we're trying to bucket out all of our damages. So as time progresses and governments step in, or insurance companies loosen up their belt because they don't want a government to step in, that we are tracking out all the buckets of costs so that we're prepared if we see the opportunity. And we've put everyone on notice just as a precaution.
Bree, how about you?
similar, and we don't have probably as much there as maybe Sloan's business does, since are so essential and are continuing. Ours is more the slowdown of need of our products as well, right? And the same thing, we have coverage for property, and we have a lot of coverage for fire, right? We're a paper company, and all of our manufacturing buildings have a lot of insurance coverage for fires and other natural disasters. And so then the question will be, well, is a pandemic really one of these issues? And what is the damage, again, to the products? If we don't really have damage to products, since COVID's not necessarily going to infect our products, it's more going to be, we're just not selling them if it gets to that point. And then the insurance companies will probably have a better argument that that's not necessarily a force majeure issue. So we are still, like she said, tracking our losses, tracking where our production is going down, and where we might have losses, and we're taking it a day at a time right now.
I think there are some interesting insurance products out there. For example, there's contingent risk insurance, events and things like that. And so obviously the cancellations from those events, if they have coverage, may well be impacted, but that does not mean that there will not still be an argument about why they were impacted and whether or not there's a true force majeure clause within the insurance policy, or it could be implied by law. So I think there's going to be quite a lot of discussion, he says euphemistically, around that issue. And I just wanted to touch on a couple of other things that are going to be impacted on the insurance side of things, because it's something that people are very interested in. Clearly, if you have an employee who is ill as a result of the coronavirus, they're going to look for recovery under their workers' compensation claim in the event that it is that they have a claim, and that's fairly straightforward. But what about their spouse, their significant other? What about other people they get impacted by? Those sorts of things are going to be involved going forward. And then, of course, there's things like D&O, directors and officers. Large publicly traded companies may well find themselves being targeted as failing to prepare. And that is a whole different area, but I just want to make sure we throw it out there, because even in that sort of situation, there could well still be an impact in relation to whether there is or is not cover and the ambit of the cover, etc.
I do think that even with workers' comp, it may not even be very clear, right? If certain companies have workers who are getting sick, right? Then the question is, did you really get COVID or your sickness at work? And you're still going to have causation issues there. It could just be that your medical benefits cover that and not workers' compensation. I think those claims are going to come up as well.
They're going to be highly disputed, I think. So we're also an essential service, and we're a first responder. We're crewing up 85 boats every day with multiple crew members. And I think for us, the way that we want to deal with our workers who are trying to make, for us, it's Jones Act for mariners, Jones Act claims. And then we do have family members who are impacted, although they have been the originators thus far. The way we're looking at it is we're ticking and tying out to what are the CDC guidelines, what are the WHO guidelines, what is the federal, the state, the local. We're tracking them. We have somebody checking all the sources every other day, so 2 or 3 times a week, so that we can consistently make the argument that we have done everything in our control as a first responder and essential service provider, that we can keep them under the Jones Act, and we can defeat what we think will be inevitably tort claims, where we will file, we will submit the claims underneath our GL policies. but that we think we will have a variety of claims from either someone getting sick or loss of the services of a employee. Hopefully not, but someone could pass from it. So the adherence to the guidelines down to the local level, I think, is going to be a key element, not only in protecting yourself from those cases, but ensuring that your insurance company doesn't reject your claim. And I think that's an important aspect we can't forget, is that if we're not doing and we're not communicating with our insurance companies as these claims arise, then our insurance companies could reject the claim because we didn't closely adhere to whatever they're coming up with now because we forgot to ask them in our hurry.
I think you make a great point. I'm going to ask Joe this question. How important is mitigation in relation to any kind of claim, whether it's a contract claim under force majeure, or whether it's a claim for force majeure, or alternatively an insurance submission?
Well, it's essential. And trust me, the insurers are going to be looking to that. The insured's duty initially is, and Sloan touched on this, giving proper notice, making sure you're staying in communication, you're giving notice of the claim. That's the insured's initial duty, is to give the insured notification of a covered loss. The insured is going to immediately, even in this culture of cooperation that we seem to be in right now, their first instinct is going to be to look at potential, is it a covered event, first of all, and secondly, is there an exclusion for any reason? And failure to mitigate, it's always at the top of the checklist, and it's not going to be any exception under this. And the thing about this is, I mean, in normal types of losses, I would say like a fire loss, for example, where companies, they kind of know what to do. What do? We go through the checklist of all the things we can do, arranging other suppliers and vendors, clearing away debris, other mitigation factors come into play. We're in an area now where, as Sloan correctly pointed out, the last time we've really faced global pandemic at this scale is over 100 years ago. So it may be in the flurry of confusion and activity that mitigation matters are not undertaken. So cooler heads are going to go through a checklist and say, this is really bad. It's probably something we can potentially make a claim for, but what can we be doing in the meantime? What can we do to ameliorate this loss, workarounds, and just force yourself to go through those checklists. So when the insurers assert that you haven't mitigated, you've got your list. This is what we did. We made every effort to find alternate suppliers. We made every effort to clean up the facility or make repairs or to do whatever. And those types of losses, with the pandemic type of loss, are there alternatives to if you've got a particular factory configuration that doesn't allow for social distancing, it might be more difficult than if you can allow for that. So going through that and making sure, if you can only put out 50% of your normal productivity, but you can do that, you need to be doing that.
Yeah. Jay, thank you. I think it's helpful. It seems to me that there could well be quite a significant role for the accountants in this world, whether it's the internal financial controllers and chief actuaries, if there are actuaries, or whether it's external forensic accountants. Bree, in terms of assessing your loss and damage, to what extent do you do all of that in-house, or if you're going to present a claim, whether it's under contract or insurance, would you go externally to a forensic accountant?
We would start internally, but we are a very lean company. I mean, just our legal department alone, we only have 3 attorneys. Even our financial financial group is lean as well. So they would probably pull in someone externally very quickly, but it would be with our base of the numbers that are set inside that kind of get our business unit moving, saying, okay, this is where we are. We're going to move this over to the external entity so that they can run with it. And then we can turn all of our people back to their day jobs, really.
Yeah. And Sloan, can I ask you the same question?
Sure. So we're a wholly owned subsidiary of a private parent company. Our parent company is more built out in the accounting and finance and treasury departments. So we would likely keep it inside. We also have a captive insurer. And so we are typically only looking at our excess layers when we're talking about insurance recovery. So we have a forensic accountant in the parent company, and we would no doubt be combining our claims likely with the other, so there's a total of 22 business units, total independent business units, lines of business. And so some of them are also maritime, so they'll get folded up to maximize the recovery at the parent company level. But at our subsidiary levels, like Bree's company, we're also exceptionally lean, so our subsidiary would not be able to handle it. We also would run it through our auditors. We would run it through the auditors because we wouldn't want to have a problem at the end of the year when it's the audit time and have the auditors flag whatever claim we submitted as problematic.
Thank you. It just kind of struck me that it is the same issues as it always is, which is liability and quantum. And I think in today's world, quantum is going to be as important as liability, because obviously there's the tremendous potential for dispute. So I think it's going to be interesting to watch how that develops. And then I wondered if we could just finally, because we're really up against our time, I was hoping to finish around about 12:45, but if I could just spend a couple of minutes and ask you to bear with us. Talking about consumer claims that may be impacted by force majeure, because it sounds an oxymoron. It sounds like a consumer claim is a tort claim, and consequently, has the issue of force majeure has no relevance. However, in preparing for this webinar, it seemed that many of the consumer claims and potential class actions that could arise have historically been defended by insurance. And if those insurance policies have force majeure clauses, then the landscape of that litigation may well change quite dramatically. So I just wanted to end with just a little discussion about whether practitioners should, even in a consumer claim, think very carefully. And you can imagine a situation where, for example, a nursing home may have an arbitration clause, which may capture any dispute arising out of any loss or injury to somebody who is in that nursing home. That may it may govern, it may not govern. It depends on your jurisdiction and it depends on the language. But I think in those situations, I think we're going to see force majeure being used as both a shield and a sword. And I borrowed Bree's phrase for that one, so I do apologize. And so even in the field of consumer demands, I think the word force majeure is going to arise, certainly with respect to who may or may not be paying for any such claims.
I think risk mitigation or mitigation of the risk is going to be so significant on the consumer side. And companies are going to have to look at how much money they can afford to spend so that their insurance companies can't use their force majeure clauses as a sword.
Yeah.
Well, and I think the insurance companies are really going to have a fight to show why the force majeure even applies to them, right? And what is it that has affected them to prevent their performance of paying forward for the insurance policies, unless it's something, I mean, their ability here is really going to be, we can show that this is not covered by your insurance. And that's where their fight is going to be. I think they'll have a harder time saying it's force majeure.
Well, thank you very much for listening in. And I think we're up to our allocated time. I just wanted to thank Sloan and Bree in particular, obviously Joe as well, but we very much appreciate the input that Sloan and Bree have provided to what is likely to be a significant topic for corporations over the next 1 to 2 years. This is not something that is just going to be now. The ramifications, we believe are going to unfold over time. So I thank you for listening. Appreciate it.
Thank you for having us.